Morning. Today we are going to analyze one problem question on mortgage. Disclaimer: the video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Let's start with the problem question. Ellie, a dressmaker, owns the registered freehold title of Nuptials, a bridal gown shop, where she also lives. In 2019, the Harmony Bank refused to lend her the money she needed to renovate her shop. She therefore approached one of their suppliers, Fancy Fabrics. It agreed to lend Ellie the money. The repayable was 25 years and secured by the way of a legal mortgage or the registered title of Nuptials. The mortgage deed contained the following terms. Early must buy all her supplies of satin from Fancy Fabrics at the prevailing market price. A Fancy Fabric has a right of first refusal if Ellie ever decide to sell nuptials. Ellie's monthly interest rate will be variable at Fancy Fabric's absolute discretion, but it will never be less than 7% above the standard variable rate charged by the Harmony Bank. Almost 2 months ago, Ellie business ran into financial difficulty when she failed to make one of her monthly loan repayments. Fancy Fabrics wrote to notify Ellie that it will need to protect its position by increasing the variable interest rate by 1% for each of the next 6 months. Fancy Fabrics letter also mentioned that it has evidence that Ellie had been buying satin from an overseas supplier. Ellie is about to miss a second month's loan repayment. Fancy Fabric is considering taking possession of Nuptials so that it can arrange a quick sale at auction. Ellie has just had an email inquiry from Tanya, owner of the forward wedding, a chain of bridal wear shops, asking if Ellie might consider selling nuptials. Ellie is therefore keen to stay in possession of nuptials so that she can arrange her own sale because she believes doing so will maximize her chances of releasing the best sale price. We have to advise Ellie about the validity of the terms of the mortgage and the rival proposal or the possession and sale. Validity of mortgage terms. Class 1, the requirement to buy supplies from Fancy Fabrics. This class may be challenged as a clause on the equity of redemption, which refers to the terms that restrict the borrower's ability to redeem the mortgage. The case of Biggs versus Hodinot illustrate that such classes can be deemed oppressive and unconscionable. Ellie's reliance on Fancy Fabrics for supplies may raise concerns about her ability to operate independently and could be viewed as a restraint of trade. The fact that Ellie must buy at the market price may help her argument as it indicates she is not being forced into an unfair arrangement. However, the unknown duration of this requirement could impact her case. This term resembles a collateral advantage that might restrict Ellie's freedom to trade. Historically, courts have held that such terms can be enforceable as long as they are not deemed unconscionable or oppressive, as discussed in ESO Petroleum Collimeter versus Harper Garage. However, if the court finds that this requirement significantly restricts Ellie's ability to operate her business, it may consider it a restraint of trade, which could be invalidated. Next, we are moving to the class 2, the right of first refusal. The right of first refusal is generally enforceable if it is clearly stated in the mortgage agreement. However, it could be seen as a clag on the equity of redemption if it is effectively prevents Ellie from selling her property freely. In Jones versus Morgan, the court indicated that such terms can be struck down if they impose an undue burden on the mortgager's right to redeem. This clause may be problematic as it conflicts with the principle that the mortgage should be redeemable in full upon repayment of the debt. The essence of the mortgage is that the borrower retain the right to sell the property. In Jones versus Morgan case, the court upheld the right of first refusal, but the context and the specific of the argument differed. Ellie could argue that a right of first refusal is less intrusive than an option to purchase, but still infringes on her right to sell freely. The class 3 of variable interest rate, the variable interest rate class that allows fancy fabrics to set a rate at its discretion as long as it is above a certain threshold, could raise issues of unconscionability under the Consumer Credit Act 2006. The court have emphasized that lenders cannot exercise discretion in a capricious manner. As seen in the Paragon Finance versus Nash case, Ellie could argue that the increase in the interest rate is excessive and unfair, especially given her the current financial difficulties. Variable interest rates are generally acceptable. However, the stipulation that it will never be less than 7% above the bank standard variable rate raises the question of fairness. As seen earlier, the Paragon Finance was Nash indicates that the term may be deemed unconscionable if they impose excessive burden. Early may challenge the increase as a breach of an implied term regarding the fairness in the adjustment of interest rates. The overall rate may not be inherently unconscionable, but arbitrary increase could be problematic if it disproportionately affects Ellie's ability to repay. So the rival proportion over the possession and the sale, the possession by the fancy fabrics. The fancy fabrics has a right to take possession of the property due to Ellie's default on the loan repayments. However, the mortgagee's power of sale is typically exercised only after possession has been taken, as emphasized in Cookme Brick Co. Limited versus Mutual Finance Limited. If Fancy Fabrics seeks to take possession, it must follow the proper legal procedures, potentially including the seeking a court order depending on the terms of the mortgage. Under Section 101 of the LPA 1925, Fancy Fabrics can exercise its power of sale since Ellie is in default of payments and has breached her obligation under the Section 103 of LPA 1925. If Fancy Fabrics proceed with the sale, it must ensure compliance with the duty to obtain a true market value, as seen in Cookme Brick Co. Limited versus Mutual Finance Limited. A quick auction sale could risk not achieving this value. So the fancy fabric's power of sale. What is the Ellie's position? Ellie may argue from the exercise of discretion under Section 36 of Administrative of Justice Act 1970, which allows the courts to postpone the possession proceedings if it serves justice. Given her circumstances and efforts to sell, she should articulate a clear plan to demonstrate her potential for a successful sale. The enquiry from Tanya about purchasing the Nuptials could strengthen Ellie's case for remaining in possession, especially if she can show that a sale to Tanya would be beneficial. Ellie's desire to sell Niftyl herself to maximize the sale price is supported by the principle that the mortgagor should have the opportunity to redeem their mortgage and sell the property in a manner that is in their best interest. The court have generally favored the mortgage's right to sell the property as long as they are not in default of the mortgage terms that would affect their right. In Knightsbridge Trust versus Bryan, the court upheld that the mortgage's right should not be unduly restricted. Ellie may argue that taking possession now would be premature and that she should be given a chance to sell nuptials to sell her debts. To conclude, Ellie has a ground to challenge the enforceability of both the supply requirement and the variable interest rate due to the potential unconscionability and restraint of trade. The right of fast refusal may also be contested as a clog on her equity of redemption. The Ellie should be advised to communicate with Fancy Fabrics, asserting her rights to arrange her own sale. She might negotiate the terms or contest the possession should Fancy Fabrics attempts to encourage their rights aggressively. Ellie has several legal avenues to challenge the validity of the mortgage terms, particularly concerning the classes 1 and 2 as a potential clause on redemption and restraint of trade. Variable interest rate class 3 could also be contested based on fairness principles. In terms of possession sale, while Fancy Fabric has a legal right to sell, Ellie can argue for the discretion to remain in the possession under the Section 36 of AGA, especially if she has a viable sale option. Ultimately, her ability to stay in the possession will depend on how convincingly she can demonstrate the potential for a successful sale and the fairness of the terms imposed by Fancy Fabrics. Thank you.